Good morning, everybody. Thanks for being here at today's hearing entitled An Examination of VA's Misuse of Employee Settlement Agreements. Since 2013, when this committee began examining accountability measures in earnest, we have seen a recurring practice in which VA frequently enters into settlement agreements with employees who are resigning or who have been proposed for disciplinary actions, as opposed to taking the steps to follow these personnel actions to their final disposition. These agreements are binding legal documents between VA and the employee, which lay out the terms for, in most cases, the employee's departure from the department and their agreement to drop any current grievance or appeal to the Merit Service Protection Board, the U.S. Equal Opportunity Employment Opportunity Commission, the Office of Special Counsel, or any other entity. While in theory I think these agreements are useful tools to avoid lengthy administrative or legal disciplinary processes, but it is clear that the potential overuse of these agreements stems from burdensome civil service laws that make it difficult for VA managers to appropriately discipline VA employees. In an effort to make the disciplinary process more convenient, VA often agrees to pay out thousands of taxpayer-funded dollars both to the employee and their legal representation, as well as other benefits for the employee to simply just go away. It's because of this committee's continued investigation into personnel matters at VA and my own, what I think is a healthy skepticism about the lack of transparency in VA's potential overuse of these agreements, that last October I sent a letter to the Secretary requesting copies of every settlement agreement that VA had entered into since July of 2014. Earlier this year, VA complied with my request and provided copies of 208 settlement agreements for the committee to review. An analysis of these documents paints what I think is a disturbing picture of VA's use of these agreements and raises more serious questions about who really benefits from these settlements. Is it the taxpayers or veterans, or is it the wayward employee themselves? In 72% of the settlements reviewed, the employee received monetary compensation directly to them and or their attorney, which totaled just over $5 million. The average amount that VA paid to employees as part of their settlement was $24,305. The largest settlement was received by one individual. It was $225,000. Another concern beyond just these large monetary payments is that 96% of the settlements that we reviewed, the discipline that was proposed or finalized against the employee was not included in their permanent employee record. I think by allowing these records to be left clean and by allowing employees to negotiate for a positive or a neutral reference for future employers, VA management has made it much easier for the employee to obtain a job in the future in another federal agency or the private sector, irrespective of their behavior at VA that caused their termination or their resignation. For example, in particular, one case, an employee was proposed for removal due to reports of hostility in the workplace. The employee, however, received $80,000 and a totally clean record. I know that Ms. Bradley will remark that VA's use of these agreements is supposedly in line with other federal agencies, but as we all remember, our parents telling us as a child, if somebody told you to jump off a bridge, would you jump off a bridge? Comparing ourselves to the rest of the federal government is not necessarily the appropriate way to do a comparison in this particular instance. I also wonder what type of message that VA is sending to other good employees when they allow bad employees to settle for thousands of dollars just because it would be too expensive or possibly embarrassing to litigate. I understand the pressures being placed on VA managers to make the right call in these situations is immense. And there's always a judgment call to make as to whether these settlement agreements are warranted, but the review of these documents raised three important questions that I hope we're going to be able to talk about today. First, what type of review or training has VA Central Office provided to managers in the field on how to use these agreements? What part of the budget are these damages paid out of, and who reviews the payments? Second, are these settlements being used as a way to buy off or to silence whistleblowers whose choice is between accepting monetary settlements or retaliation or abuse? I know in one case where this appears to be happening, where a whistleblower has been offered over $300,000 to quit. And I'm interested to hear from Mr. Bachman at OSC about this specific case and another similar instance. And thirdly, and most importantly, it would seem logical that any time VA agrees to pay out damages to employees, that this is at least a tacit admission of guilt on behalf of the agency. In these circumstances, what type of review or proposed discipline does VA provide to the employee who may have retaliated against whistleblowers or participated in prohibited personnel practices which created the need for these agreements in the first place? Well, I understand that simply settling with an employee in a certain circumstance can be a great tool for the department due to current lengthy disciplinary processes required by a broken and antiquated civil service system. It is this committee's job to ensure that they are being used judiciously and with great care of taxpayer dollars. With that, I yield to my good friend, the ranking member, Mr. Takano, for any opening statement he may make.
Thank you, Mr. Chairman, and we are indeed good friends. We are here as a part of our ongoing responsibility to oversee the Department of Veterans Affairs to investigate how the people's money is being spent by the VA and why. During today's hearing, we will examine the settlement agreements VA has entered into with employees over the past 3 years. We want to understand what factors VA considers when engaging in alternative dispute resolution, which often results in settlement agreements between parties. We also want to learn why it is important that local VA managers have the flexibility to resolve employee complaints based on the individual circumstances at each facility. Most importantly, we want to know how VA employee settlement agreements have affected whistleblowers in the past 3 years. Now, we can all agree that their courage in coming forward in Phoenix, Philadelphia, Toma, and in many other places has been crucial to helping to reform the department. We want to make sure these settlements are not being used to silence whistleblowers, and that a settlement between a whistleblower and the VA does not preclude consequences against the offending supervisor. So, thank you, Mr. Chairman, for giving us the opportunity to examine the VA's use of settlement agreements in detail today and to determine whether they are serving the safety and well-being of our nation's veterans, the interests of VA employees, and the costs to taxpayers. Thank you, and I yield back, Mr. Chairman, by the balance of my time.
Thank you very much. I want to welcome our first panel of witnesses to the table. With us today is the Honorable Lee Bradley, the General Counsel for the U.S. Department of Veterans Affairs, who is accompanied today by Mr. James Manker, the Acting Principal Deputy Undersecretary for Benefits, and Mr. Steve Young, the Acting Deputy Undersecretary for Health, for Operations and Management at the Department of Veterans Affairs. And we also have Mr. Eric Bachman, who is the Deputy Counsel for Litigation and Legal Affairs with the U.S. Office of Special Counsel. We appreciate all of you being with us today. Your complete written statement will be made a part of the record without objection so ordered. And Ms. Bradley, we'll start with you and recognize you for 5 minutes for your opening statement.
Good morning, Chairman Miller, Ranking Member Takano, and members of the committee. Thank you for the opportunity to discuss settlement agreements between the Department of Veterans Affairs and its employees. Addressing employee disputes in the federal government, which manifest in complaints of discrimination, allegations of prohibited personnel practices, such as whistleblower retaliation, and appeals of proposed disciplinary actions, is a particularly daunting challenge. At VA, managers at every level are required to do this in the most cost-effective manner with the least amount of disruption to the effective functioning of the organization as it carries out its statutory obligations to our nation's veterans. Moreover, VA managers must resolve employment disputes consistent with the vital goal of building and sustaining high-performing teams and workplace cultures that will achieve excellent outcomes for veterans at good value to the taxpayer. Congress clearly intended that federal agencies have the authority to settle matters expeditiously without resorting to protracted litigation. In the 1990s, faced with litigation dockets clogging federal courts and administrative tribunals, Congress passed 3 laws that were designed to reduce the cost and time required to litigate many disputes by requiring federal agencies to adopt a policy encouraging the use of ADR, alternate dispute resolution, and mandating that federal trial courts make ADR programs available to litigants. As a result, the judicial and administrative bodies that have jurisdiction to investigate and decide federal employment disputes, and these are the Equal Employment Opportunity Commission, the Merit Systems Protections Board, the Federal Labor Relations Authority, and the Office of Special Counsel, have adopted policies and practices that encourage or require settlement negotiations. VA's use of ADR and execution of settlement agreements are not only proper, but critical to maintaining a positive workplace of high-performing teams to carry out VA's mission. It is noteworthy that many of these agreements contain no monetary payout provision. With nearly 350,000 employees, VA is simply not resourced to litigate all employee disputes to final adjudication without significantly and detrimentally impacting service and benefit delivery to veterans. Furthermore, for example, in reviewing the most recent data maintained by the EEOC, the percentage of formal EEO cases settled within VA is within 2% of the average percentage of formal EEO cases settled in other cabinet departments. That said, oftentimes the best course of action is to litigate the matter all the way to judgment or final decision. VA is not reticent to litigate. Indeed, the presumption is that we will litigate most personnel disputes, but it is our obligation and in the best interest of veterans and the taxpayers to consider the merits of settling an employment dispute on a case-by-case basis. In each and every case, there is a delicate balance that must be struck between expediting the resolution of an employment dispute and formal vindication of the agency's position in a federal court or administrative board. So what is the business calculus used to decide whether to litigate or settle? Here are the key factors that VA management officials consider. In consultation with legal counsel, management officials will evaluate the litigation risk, meaning the strength of the evidence and availability of key witnesses. They will also consider the monetary cost of litigation. In other words, this is a key business decision, and that will include the administrative resources needed to investigate and process a complaint, loss of employee productivity during depositions and trial testimony, deposition and transcript costs, and if VA does not prevail, payment of compensatory damages, back pay, interest, and attorney's fees. Managers must also assess the disruption and divisiveness that litigation will likely create for the facility's workforce. In addition, consider that it is not unusual for an EEO complaint to take between 18 to 24 months just to get to a formal EEOC hearing. That's time in which members of the work unit can become mired in the adversarial drama unfolding and lose focus on teamwork and achieving mission objectives. Management officials also settle cases when it is determined that the employee has been legitimately aggrieved, and it is simply the right thing to do. Over the past 2 years, for example, working with the Office of Special Counsel, VA has been able to negotiate expedited settlements with employees who have been the victims of whistleblower retaliation. Finally, and importantly, settlement does not end the obligation of the department. If a settlement agreement is reached with an employee who filed an EEO or whistleblower retaliation complaint, VA has a duty to determine whether there was any wrongdoing by another employee that necessitated that settlement, and if so, what disciplinary action should be taken against that responsible management official or offending employee. Accountability actions must be based on sufficient evidence, which is typically derived from follow-on investigations conducted by the Office of Inspector General, VA's own Office of Accountability Review, other internal VA offices, or in many instances involving retaliation, the Office of Special Counsel. Regardless of the entity that conducts the investigation, VA managers are expected to hold employees accountable based on the evidence provided. To that end, VA is making meaningful strides in resetting the bar on accountability throughout the department and refocusing VA's business processes and culture first and foremost on the needs of America's veterans. That concludes my oral statement.
Thank you very much, Ms. Bradley. Mr. Bachman, you're recognized.
Good morning, Chairman Miller, Ranking Member Takano, and members of the committee. Thank you for the opportunity to testify today about the U.S. Office of Special Counsel and our work with whistleblowers at the Department of Veterans Affairs. OSC is an independent federal investigative and prosecutorial agency, and our primary mission is to protect employees, is to safeguard the merit principles by protecting employees from prohibited personnel practices, in particular from whistleblower retaliation. Since 2014, OSC has seen a dramatic increase in the number of whistleblower retaliation complaints filed with our office by VA employees. As our docket of VA cases has grown, so too has our rate of securing favorable actions for VA employees, which has helped courageous employees restore successful careers at the VA. Since 2013, the number of VA prohibited personnel practice complaints filed with our office has increased by 67%, while the number of favorable actions that we have obtained in these cases during that same time frame has increased by 232%. We are currently investigating approximately 300 whistleblower retaliation cases related to VA whistleblowers across the country. And settlements are an important and effective tool for OSC to use in handling this large caseload for two reasons. First, our top priority is to help the whistleblowers as quickly as possible, and they can often get relief far more swiftly through a settlement than through a litigation context. Second, the whistleblower and the agency can often be more creative in the type of relief that they agree upon than can be done through a litigation context. For example, OSC recently mediated a settlement between the VA and Brandon Coleman, who's a whistleblower from the Phoenix VA medical facility. The settlement included a new position for Mr. Coleman and moved him away from his previous chain of command. And this was a positive outcome for Mr. Coleman as well as the veterans he now serves, and would not have been possible without OSC's Alternative Dispute Resolution Program mediating a voluntary settlement between the VA and Mr. Coleman. Through settlements, OSC has helped hundreds of whistleblowers at federal agencies across the government. And at the VA alone, we've secured 169 favorable actions in the last 2 years. We are proud of OSC's role in protecting whistleblowers and helping to put employees back into their jobs so they can continue their important service to veterans. When a whistleblower and the VA settle a case, their settlement does not necessarily end OSC's role in the case. OSC recognizes that disciplining managers who retaliate against employees is an important tool to promote accountability. Accordingly, even where a whistleblower settles their individual claim, OSC may still investigate the case for potential discipline against alleged retaliators. For example, in whistleblower retaliation cases at the VA's Puerto Rico facility, OSC has investigated and obtained corrective actions for several whistleblowers. Although these cases have either settled or are in settlement negotiation, OSC is continuing to actively pursue its investigation of several high-level officials at the Puerto Rico VA for potential discipline. Notably, even though it takes significantly more time and resources to complete disciplinary investigations, in the first 4 full years of Special Counsel Carolyn Lerner's tenure, which was from 2012 to 2015, OSC more than doubled the number of disciplinary actions taken government-wide as compared to the previous 4 years. We appreciate the committee's attentions to the issues we have raised and your interest in our efforts to protect and promote VA whistleblowers. I thank you for the opportunity to testify, and I'm happy to answer your questions.
Thank you very much, Mr. Bachman. You had referenced the issue about the supervisor who dressed up as a particular employee, and that employee has now been moved to a different. But Ms. Bradley, what I want to know is, What happened to the people who actually retaliated against this person? Was there disciplinary action taken against them?
So what I want to tell the entire
Get your microphone.
What I want to tell the entire committee is that what we've been working very hard on is a process to hold all people that have engaged in some form of either retaliatory behavior, discriminatory behavior, or acted inappropriately, hold them accountable. So while I am not able to actually talk about specific accountability actions in a public hearing,
No, I just want to just answer the question. Was anybody held accountable for what they did?
they either have been held accountable or will be held accountable through the process that we've put into place, which again, I want to go back to, we've got to do a follow-up investigation to get evidence that will be the basis of the accountability action so that it will be sustainable on appeal. We've got to make sure that these actions stick.
Is a photograph of somebody dressed up as an employee and making fun of them not good enough evidence?
Again, I am not able to talk about the specific actions that we have or intend to take in that particular matter, but as we've said before, we're happy to brief you in private, and I believe we have had a variety of leaders brief the committee on individual cases in private.
I also want to talk about the Puerto Rico issue with Ms. Lopez. I think it is in the news these days. According to media reports, she was originally fired for failing to discipline a VA whistleblower that was disclosing legitimate yet damaging information about a senior VA manager at the Puerto Rico VA Medical Center. And following further investigation by OSC, they concluded that Ms. Lopez should be reinstated. So has Ms. Lopez been reinstated, and if not, why not?
Do you want me to take that first? I think we can answer this in concert with one another. We are in the process of conducting 2 follow-up investigations to get the evidence that we need. The Deputy Secretary has been briefed at least preliminarily on what we've learned so far, and we will be prepared to tell the committee what the final accountability resolutions are in this matter as well as some related matters at that facility, I think in very short order.
Can you tell me when this actually happened? I don't have a date, so I'm sure the committee does.
cannot.
I'm sure that the OSC can if you can't.
Yes, the actions with Ms. Lopez occurred during 2014. When Ms. Lopez filed a case with OSC, we took a look at the available evidence and determined at that time that we believed a stay of a proposed removal of Ms. Lopez was in order. We discussed that with the VA. The VA did agree to stay it. By that, I mean to hold off on actually removing Ms. Lopez while we continued our investigation. So she has been reinstated. My understanding is that they are currently in settlement negotiations, though.
So the press has reported there's a $305,000 settlement agreement on the table if she agrees to resign from VA. Is that true?
Again, Mr. Chairman, I really am not at liberty under the Privacy Act to discuss the specifics of the case, but I'd be happy to meet with you in private and talk about it, or bring over experts that are dealing with that case right now and talk to you or the committee about that.
Mr. Bachman, can you discuss it?
Because it is an ongoing open case with active settlement negotiations between Ms. Lopez, her attorney, and the VA, I do not believe I should discuss the specifics. I don't want to undermine their opportunity to settle the case.
Okay, well, I don't want to undermine their opportunity to settle the case either, but it's my understanding that the first offer was $100,000. It is now ballooned triple that at this process. And you know, I want to know how VA can expect to build a culture that encourages whistleblowers to come forward when VA takes such a hard line against those like Ms. Lopez.
May I answer that?
I'm looking right at you.
This is a key priority for the entire leadership team of VA. So it started 2 years ago with Secretary McDonald saying that we would change our culture and it would be an open culture, one that would be free of fear, that would encourage people to come forward and raise concerns. As a result, we have seen a dramatic spike in the number of people who've been willing to come forward and raise concerns. He did this by making the somewhat unusual public statement repeatedly about giving out his private cell phone number. And then he told all of us as senior leaders that he expected us to do something very similar, to make sure that all of our employees know that first and foremost, it was our sacred obligation to ensure that the environment was a place where
Thank you.
people could raise
My
concerns.
time has expired, and I appreciate it very much. And unfortunately, Mr. McDonald's phone goes to voicemail, just like a lot of the hotlines that they have right now, which I think is very unfortunate. And one quick question. Does it make sense that over 96% of the agreements that were made have allowed employees to leave the agency with a totally clean record?
Is that okay? I don't know that that is accurate, but I can tell you that clean records.
Just suppose that it's accurate.
I can tell
If
you.
it is accurate, does it make sense, yes or no, that 96% would leave with a clean record?
I can only speak to what our current policy is, which is that clean records, while they do occur every once in a while, they are disfavored.
96% of the time.
I'm speaking from my time as the general counsel. They are, MSPB disfavors them, my attorneys disfavor them, and furthermore, what a lot of people don't understand is that along with a clean record usually comes a request for VA to provide what's called a neutral reference. And anybody at any other federal agency that calls VA and says, well, can you provide a reference on this individual? When we say, well, we can provide you a neutral reference, that means something to them. They know that there is something that's been going on with that person in the workplace.
Thank you very much. Mr. Takano.
Yeah, I am looking for a little context for some of this. Are the settlement agreements the VA has entered into in the recent past, from 2014 to the present, more costly or more frequent in comparison to other federal agencies and the private sector? Go ahead, counsel.
Well, you have to understand that employment disputes really fall into 3 to 4 buckets. So let's start with EEO complaints. Those are complaints of discrimination based on race, sexual orientation, age. They could be harassment-related complaints. Those make up the lion's share of employment disputes in the Department of Veterans Affairs and, I believe, in other federal agencies. So in looking at the data, and this is all reflected not by me. If you look at the EEOC's website, they have annual reports and they put the data on their website, and it shows that the rate of settling cases, EEO-related cases by VA, is within, as I said in my oral statement, 2 percentage points or so of all the other cabinet departments. So that's one bucket of cases. If you look at the MSPB cases, those are the ones that go to the Merit Systems Protection Board, the ones that are actually going to be litigated. They too, in their annual report, they show the incidence of settlement amongst all of the federal agencies. And you will see that our incidence of settlement is around 71%, which is very closely aligned with I will call them our 12 sister agencies. So the key is that there's nothing that's going on at VA that's out of whack with respect to the practices of other cabinet departments.
But I'm interested in private sector comparisons.
Well, I spent not a lot. I spent some time in the private sector, and I was also the chief of staff of the American Red Cross for about 3 years. And I can tell you that the CEO of a company that I worked for as a lawyer or at the Red Cross, from our perspective, almost never was protracted litigation good for the bottom line. It's very, very costly to any entity to engage in litigation and everything that leads up to litigation for 18 to 24 months.
Okay, well, Ms. Bradley, with this last question that the chairman asked about references, neutral references,
Right.
I seem to recall in my days as a member of the Board of Trustees at Oversight Community College that as an employer, if we gave negative references, there was some liability that accrued to the employer. Is that true also with federal agencies?
I don't want to say that there is. I think it's always a concern that you could be sued for it. I don't know if it's a legitimate suit, but I think a lot of senior managers are afraid of that. But I still think the important point is this notion that VA regularly engages in a clean record settlement is a misnomer. We're moving away from them. We haven't completely eliminated them, but we're moving away from them. Just as we're moving away from non-disclosure agreements, I just recently sent out a memo to all of the attorneys in OGC and said that non-disclosure agreements are to be disfavored, and in the rare cases where we feel like we need to enter into one, it should be limited just to the specific terms of that settlement.
Great. I want to move on to another question. My time is limited. Please share with the committee the nature of what settlement agreements represent. Are settlement agreements an admission of guilt by either side?
I guess at their very core, they represent a mutual and final resolution of an employment dispute. So if you litigate, if you go all the way to an adjudication before the EEOC or the MSPB, what happens there is those bodies have to attribute fault. And sometimes it's important for the agency to go all the way to one of those boards or to a federal court in order to attribute fault. But oftentimes employment disputes are something as simple as a person says, I didn't get a promotion, and I feel like I was unfairly treated. I feel like maybe I didn't get the promotion because I am gay or because I'm an African American. And so you want to try. It's in your best business interest to talk through those issues at the most local and informal level possible, because you really want to get that person back onto the team working on the agency's mission and not being kind of sidelined and engaged in, well, you know, I have a deposition next week or my litigation is coming up. So it's the mutual and final resolution of a matter that counts, but it doesn't tie our hands. We are able to then pursue accountability.
Mr. Chairman, will you permit me to ask one follow-up? Thank you. I appreciate that. So I just want to make sure, as we all do, that settlement agreements between the VA and whistleblowers. So what I hear you saying is that settlement agreements are really a mechanism by which both parties can efficiently come to a resolution on a difficult situation. But I want to make sure, as we all do, that settlement agreements between the VA and whistleblowers do not preclude accountability for bad supervisors. In the case of a settlement between the VA and a whistleblower, does the VA still have a duty to determine wrongdoing by an employer that necessitated a settlement?
Absolutely, we have a duty. And there is nothing in the settlement agreement that precludes us from pursuing accountability. In fact, that is the most important piece, I would argue, in this whole process. That's why we have the various mechanisms for people to raise concerns and then to use ADR to try to resolve their concerns. But it's up to us to make sure that we have the right leaders in place and that we address workplace culture issues. It's our obligation to pursue accountability. And remember, the agreement, the settlement agreement, is between the aggrieved party and the agency, not between the person who was engaging in the wrongdoing. So yes, the agency is not waiving its rights in any way, shape, or form in entering into that agreement.
Okay, Mr. Chairman, my time is up, but I hope somebody will ask a question related to whether the agency has pursued further discipline after a settlement has been reached with the supervisor.
Thank you very much, Mr. Lamborn. You're recognized.
Thank you, Mr. Chairman, for having this hearing. Thank you for all the witnesses for being here. Ms. Bradley, would you make any changes to existing civil service laws to make it easier to discipline employees so that managers aren't trapped in a system where at least it appears to us on the outside that settlement agreements are used because there's no other avenue to hold someone accountable?
So there are some important and I think helpful provisions in the House bill on accountability as well as in the Senate bill on accountability that our department supports. I think that we've made clear in our public statements and in our testimony that we do believe in strict accountability measures.
So specifically, what would you like to see changed?
I guess I'm concerned about the disparity for VA senior executives that the bill language affords. So I spent most of my federal career at the Department of Defense. So for example, recently, I was trying to hire our top procurement lawyer. And so where did I want to go? I wanted to go to DOD and recruit there because That's where they do the most contracting work. So I wanted to go back to the Department of the Navy where I had worked, or I wanted to go to the Defense Logistics
Okay,
Agency.
hurry up, be specific. My time's running out.
So specifically, when I reached out to people and said, I want you to come to VA, I need your help, they said, yeah, but you treat senior executives differently at VA. And so why would I leave my department? So that's what I'm concerned
No,
with.
you're talking about the status
disparate
quo. You're
treatment of
not,
senior
you're
executives.
saying the status quo is broken. And I'm saying what changes would, okay, I'm not going to get a good answer from you on that, so let's move on to something else. Is it discretionary with the VA in a settlement agreement to remove derogatory information from an employee's permanent record, or not to allow it to go into the record in the first place?
Well, that is the purpose of a clean record. You enter into an agreement as to exactly what will be reflected in the SFP.
So it's a negotiating tool.
It is a negotiating tool, which is why we haven't completely outlawed it. We frown on it, but there are some instances where we want the ability to be able to do that, to settle the case.
We on the committee here, I think everyone here wants, number one, the taxpayer to be protected, the dollars to be spent for the veterans' needs, and for justice to be done. Innocent people not to be punished, or guilty people to be held accountable. And if the withholding of derogatory information from someone's record is a negotiating tool, it seems to me that that's liable for abuse. Have you ever seen cases where
I think that's-
something should have been in someone's record that got removed that you think the next employee should have known about, especially if it was a federal employer?
I think you're exactly right. I think that's why we've moved away from the use of clean record settlements. I think that's why the MSPB frowns on them. So I think that you raise valid points. I don't know what to say other than we don't use them regularly, as has sort of been depicted, that that's the way we do business.
Thank you. Mr. Bachman, how would you comment on this topic?
I would note that the ability to give an employee a clean record through settlement negotiations, when we're talking about a whistleblower who's come forward, and part of the retaliation they believe they've suffered is derogatory information in their personnel file, that is a negotiating tool that we at OSC do like to have on the table for the parties, because it is important that it not follow them for the rest of their career just because they had a retaliatory supervisor who placed it in their folder. So I would just want to make sure that that ability is taken into account from OSC's perspective as well, that this clean record provision in settlement agreements often does help the whistleblower themselves.
Would you recommend any changes in the regulations or laws to make sure that that's not abused?
I don't have any particular specific recommendations on the legislation. I can tell you one observation, one area that we have mentioned that could be improved is the idea of having a permanent office within the VA whose statutory mandate is to be identifying potential problem areas, whether it's in patient care or whistleblower retaliation issues, to make sure that they can proactively respond to those ongoing or upcoming problems instead of having to react to it once it's already spiraled out of control. So that's the type of more structural improvements we think would be extremely helpful.
Okay, thank you all.
I would note for the members that the 208, I think it was, or 203 that we looked at date back to July of 2014. Ms. Bradley, you came in, I think, in December of 2014. 92%, 96, I'm sorry, higher, 96% of those were clean records. That's the records that were provided to us. So I'm having a hard time figuring out how we're doing away with it when we actually are almost at 100% clean records. Mr. O'Rourke.
Thank you, Mr. Chairman. Mr. Bachman, when you were citing the changes since 2013, you mentioned 230% plus change in favorable actions, I believe over 65% more claims being filed. Is that a sign of success Does that mean that there was this latent demand to be able to do these things and people didn't feel comfortable doing it before, and now post-2013 they do? Or is it a sign that there's a problem within the VA because this many more people feel like they have a legitimate whistleblower issue that they want to bring forward? How do we read that? You seem to cite it as kind of a success.
I think there are a variety of factors at play here in terms of why we've seen this spike in VA whistleblower complaints with our office. And I don't think there's any one factor in particular, but one of them certainly is the fact that the VA did become the first cabinet-level agency to become certified under OSC's process. And what that certification means is they've taken some specific steps to make sure that their employees are educated about their rights and responsibilities under the various whistleblower protection laws. So this may have alerted VA employees about their opportunity to come to OSC, and that may have increased their comfort level about doing that. Another factor I think that plays into this is VA whistleblowers are often blowing the whistle about serious patient care issues. And those are the types of issues that get employees motivated to come forward, and they feel like it's a really important issue that needs to be brought to light. And then I think the third factor is that OSC has been helpful or has been successful in helping whistleblowers. And whistleblowers, when they're making disclosures, when they're blowing the whistle, are starting to see results. And so I think that is also contributing to their likelihood to come to OSC.
Gotcha. Ms. Bradley, two things from the Ms. Lopez case in Puerto Rico, because I know you can't describe the case in detail and can't respond to our specific questions about it, but just to extrapolate from that one anecdote, do we have a problem within the VA of using settlement agreements to stifle whistleblowers to make them go away?
I don't think that that particular case would support that proposition. I think the proposition that is of great interest to me and to Bob McDonald and to Sloan Gibson is, once we resolve the retaliation piece, what accountability measures will we take with respect to not just one leader, but maybe several leaders? And how do we do that, and on what basis? And how do we get the evidence, and how do we pursue those accountability actions?
I know this is tough because we can't talk about the details, but you and I are drawing two different conclusions from this. My conclusion is this employee, from the facts that I understand, was trying to do the right thing. Her superiors were trying to get her to do the wrong thing. In an effort to make her go away, she was first offered $150,000, and they doubled it to over $300,000. That seems like using settlement dollars to make somebody go away who's a problem for upper management. So my question still stands: do we have a problem in the VA of using these settlement agreements to stifle whistleblowers or others who are trying to call out wrongdoing? As Mr. Bachman said, if someone's finding that patients aren't being taken care of, if wait lists are being manipulated, are they going to be paid to go away?
Right. Let's talk about the case just sort of hypothetically. If we had a situation like this one, I think that we should be concerned that that is at least what a reasonable person would conclude.
Do you feel that that's a problem within the VA? Here's the deal.
I believe it's anomalous.
I don't know. I don't have the data that the chairman has, and I want to see what he's looking at. I don't know if is this one anecdote that doesn't represent the whole? Is this the exception, or is this prevalent enough that we have a problem within the system? And so that's the question I'm asking you. I don't want to talk hypothetical. Do you, from your position, knowing about what goes on VA-wide, do you see a problem in management, not you, but people at the level that we're talking about in Puerto Rico and elsewhere? Are they using these settle agreements to stifle people who are trying to call attention to issues within the VA facilities nationally?
I think that this issue is anomalous. I see great progress being made, and I measure that by the numbers of people who feel free to come forward.
So you've seen nothing from your position, which is the best position from which to understand whether or not we have a problem. You do not think we have a problem?
I don't want to say that we have a problem, but I think it's worthy of us looking very hard at for the next period of time, like maybe 2 more years, to look at and ask that hard question. I don't want to say there is no problem. I think we are making a significant culture change in our department, and culture change is hard, and it takes a long time, and I think it's incumbent upon every leader to be asking that kind of question. You know, are we taking the easy way out here? Do we want this person to still work for VA? And who was willing to sort of pay off the whistleblower? What do we think about him or her? And should they be a leader in our department? I think those are very important questions that we need to keep asking on a regular basis.
Okay, looking forward to the answer. Thanks.
Mr. Bilirakis, you recognized.
Thank you, Mr. Chairman. Question for the panel. Is there someone currently tasked with the responsibility of overseeing these settlement agreements to make sure that they're appropriately entered into and used? And then is it the Office of General Counsel, Special Counsel, someone with the VA? I also want to know if there are audits being conducted, and if these audits are available to the public or to the VA committee as well. So who wants to go first?
I'll take that question, Congressman. VBA has several levels of review prior to entering into settlement agreements. HR directors, EEO managers, the Office of General Counsel, the Office of Regional Counsel, as well as senior leadership are all consulted for guidance before entering into these agreements. We do that to make sure that they're correct in terms of legal sufficiency, they're cost effective, and also in the overall interest of our employees, our veterans, and our taxpayers. So we look at it through all those lenses. Additionally, at the department, we do compliance reviews to make sure that settlement agreements were completed in compliance with the rules that we have in place to govern these things.
Now, let me ask you, is there one person specifically responsible for the oversight?
I would submit to you that from each of our administrations, we have a responsibility across the leadership team to look at and review settlement agreements.
Are audits being taken place, and are they available to the public?
I'm not really sure what you mean by audits. Certainly, the costs have to be monitored by the individual administration because the costs come out of their operating budgets. But I don't exactly know what you mean by auditing a settlement agreement.
Is this information available to the public?
Generally, not.
Okay, we'll get on to the next question. Ms. Bradley, when these payouts occur, do the funds come from the central office operation budget, or does it come from that particular facility?
I'm going to turn that over to my colleagues from VHA and VBA.
So, Mr. Congressman, I in my former role, I served as the CFO for VBA, and I can tell you that settlement agreements come out of our operating funds. So our very precious operating funds that we use to adjudicate claims. So again, the reason why we take these things seriously and make sure that we have all the I's dotted and T's crossed is because it comes out of the same funds that we use.
It comes from the central office's operation funds, is that correct?
It comes from our operating account, that's correct. We like to revert to
From the individual facility?
It depends on the size of the agreement, but in general, it comes from our general operating expense account, so from our main appropriation.
Are any of the you have any concerns that funds diverted from these facilities, if it comes from the particular facility, could negatively impact veterans receiving care at that particular facility?
So let me address that from VHA as a prior medical center director. Those funds come directly from the individual medical center's operating funds, and consequently, the medical center directors that work in consultation with the attorneys look very hard at every decision and make certain that it's a good business decision because it is so important because it is coming out of the medical center's funds. So the direct answer to your question concerning where those dollars come from is in VHA from the medical center level.
And if I could add to that, So I understand your point is, gosh, this money is coming out of operating budget accounts, and that could harm veterans. But it's a business decision, so you have to evaluate how much are you spending in settling the case versus how much money would need to be spent to adjudicate it all the way to final resolution. Like, what are all the expenses associated with litigating the case? That's the business decision that these gentlemen and other leaders in VHA, VBA, and cemeteries have to make. So it's not just simply the, what would the settlement cost? It's what would this cost us to litigate for some number of months or years?
Well, again, that point is well taken. However, I'm concerned that there's not enough oversight, and you don't have one particular individual appointed to oversee these settlement agreements. So I'd like to work with you on that. I yield back, Mr. Chairman. Thank you.
Ms. Brownlee, you're next.
Thank you, Mr. Chairman. Ms. Bradley, I wanted to follow up with you. In your opening comments, you talked about an accountability action it sounds like you're going to introduce here pretty soon. And you said that you couldn't really speak about it, but I was wondering if you could just describe to me what this looks like generically in terms of accountability actions after these disputes are settled.
What I was referring to is a process where we get into a rhythm, a battle rhythm, if you will, which is we ask our investigators to give us sound evidence so we can bring an action, and it can be any variety of disciplinary action, if appropriate, and then be able to pursue that all the way through the appeals and have that action sustained. That's what I was referring to, but there is something I would love to share with the committee that I think will help senior leaders and managers with accountability. It's something that's being developed in the Human Resources and Administration part of VA. I have behind me, I believe behind me, is the Deputy Assistant Secretary for the Office of Resolution Management. He's been using what I call business intelligence. It's really using data analytics to be able to give leaders better intelligence about what's happening at their facility or group of facilities. It's going to give, in concrete terms, some ideas about how many complaints have been raised or lodged at this particular facility over some period of time. How many of those cases were settled? What's the cost of settlement? This is going to give us some ability to see where we might have problems with leaders, or we might have a culture that is not conducive to a high-performing workforce. That's going to be rolled out in November. So I'm really excited about this because I think this helps us get at accountability in a more meaningful way. We have a lot of medical center directors and RO directors who are in acting positions. They come into a facility, imagine coming into Phoenix right now and trying to understand the lay of the land over like the past 5 years. We haven't given them good data analytics to be able to see where they have strong leaders and where they have room for improvement. So that is something, thank you for giving me the opportunity to talk about it. We would like to come over and share this with the committee, maybe give the committee a demonstration about how this data science project is going to work in practice.
Thank you. So, I think, I think we all can agree, and we all do agree, that the VA needs a cultural shift and a cultural change. And it feels to me as though the work that you do is really very much at the heart of that shift within the organization. And I think it's a little concerning to me where it seems as though in this settlement practice, there is a focus on time and money, and I understand that. I mean, I understand that at one level, but it seems like that's the emphasis, and rather than on the principle and the accountability. And so, I don't think you're going to get to the cultural shifts and changes that need to really permeate deep into the organization, unless we are focused more on the principle and the accountability. And yes, time and money, and I agree with your argument that we want those operating expenses to go to our veterans. But on the other hand, you know, this cultural shift within the organization is I think, very, very important. And I think the other measure you've just mentioned, one issue that it sounds to me a more of a proactive measure that your department is taking that you just described to me. And I'm wondering if there are other, you know, proactive measures coming out of your department that will help to you know, anticipate some of these personnel issues so that they don't happen, so that there is that strong cultural change, that we are a veteran-centric operation and whistleblowers are to be safe and secure, and recognizing that they're only trying to move the organization forward in a positive way for veterans. So if you could talk a little bit about, you know, the focus on principle and accountability and some more proactive measures you're taking.
I really appreciate your question. When I arrived at VA almost 2 years ago, it wasn't just my assessment, it was sort of a general assessment that we had a problem in terms of training our first-line supervisors and managers. And I mean training them, especially about whistleblower activity and protecting whistleblowers and not retaliating against whistleblowers. So we started to do some training.
My time is up, so well, maybe we can talk offline, so I yield back.
Thank you very much. Mr. Huelskamp, you're recognized.
Thank you, Mr. Chairman. A few clarifications, if I might, Ms. Bradley. You do know in your written statement that the VA does not have a national policy on these issues. Can you describe the type of training for the decision makers on these particular policies?
Again, I'm really pleased to talk about this because I think we've made some real progress. When I first arrived at VA, this became like a central focus for me. I even myself trained, but it was telephonic, all of our medical center directors on whistleblower, the laws, what a whistleblower is, what it means to actually take action against a whistleblower. Then we decided, okay, the training was good, but it really wasn't sufficient to get our supervisors and managers ready to do the right things. So we worked closely. We partnered with the Office of Special Counsel. Actually, Mr. Bachman and I worked on this with Carolyn Lerner. They helped us develop what I think is a fabulous module on whistleblower and whistleblower protection.
Ms. Bradley, if I might interrupt, let me restate the question, and I'm very interested in the whistleblower, but these settlements are not solely whistleblower agreements, is that correct?
That's correct.
Okay. But for what type of training do you have just for general employee settlements and who exactly makes the decision? You mentioned the medical director. Is there a legal counsel in every clinic that is making this decision and writing these agreements?
So I come to this position most recently from being a medical center director, so I can speak to my experiences as a medical center director. And I always worked, and we collectively always work very tightly with legal counsel in the field that provides us the information about the risks of the case, the strengths of the case, the likelihood of prevailing, the likelihood of not prevailing, and what the cost may be, so that we can make a business decision. But that is done in very tight concert with legal counsel that provides that expertise.
Local regional counsel or the central office?
It's generally the local counsel. We have senior executive service lawyers assigned across the country, but sometimes in an unusual case, they will consult with central office because we have national experts.
But you don't have a national policy.
We don't, but we don't see
Is there a
federal
memo
agencies.
here that can describe what you sent out to the, I don't know what Mr. Young's background, or were you a doctor or an attorney, or what was your background as the medical center director?
I've been an employee of VA for approaching 40 years, working from a dishwasher to a medical center director.
Okay. Do you have any legal background?
None. None.
But you're the final individual that signs off on these employee settlements?
At my medical center, I would be the decision maker. But I would also, and again, widespread practice within VHA. Any case that would be a high dollar value, a high visibility, I would certainly bump that up to my network director, and the network director for particularly high value, high visibility would bump it even higher.
Before the chairman's request, was there any consolidation or report to central office on these employee settlements across the country? Is there a threshold where you said this is an important level, $100,000? What was the threshold?
Okay.
So there's not a threshold per se. Those that are revolve around EEO, there is in fact a reporting process for those. I believe that report comes here to Congress as well.
EO, even if the complaint is withdrawn, does that end up, that doesn't end up in the congressional report. Most of these settlements, if I understand correctly, they withdraw all those complaints, correct?
I can't speak to that part of that.
Okay, I thought that was somewhere in the report. And lastly, trying to figure that out, trying to figure out who makes the decision, but there's no national policy. But is there a memo you can provide to the committee that you send out to all the medical directors? So we've got dozens and dozens of employee settlements. Here are the national guidelines. Is there nothing at all we can look at?
Again, we don't have national guidelines, but we have longstanding practices of how we work together to evaluate each individual case on its merits. That's done in close consultation with lawyers. In unusual cases, that's done in consultation with lawyers in the central office. From my experience in other federal cabinet department agencies, I don't remember there being a national policy. Perhaps there is, but I can tell you what's important is, are they getting the right level of scrutiny? Are we paying attention? In the EEO arena, for example, there are some triggers or threshold amounts that require reporting up to the...
Yeah, and that makes sense, but if the complaints are withdrawn as a function of the settlement, how do they ever move up? And lastly, and we'll come back to hopefully another round of questions, think about that, but the initial response to us was we have more whistleblower settlements, and that's the reason for this sudden increase. I understood from the secretary that we had adequately trained in the last 2 or 3 years to take care of that, but if I'm understanding here, this would suggest we are not treating our whistleblowers fairly if suddenly this is the reason for many of these settlements. And we're out of time. Think about that. If we come back around, I'll re-ask the question. I yield back, Mr. Chairman.
Thank you, Mr. Huelskamp. Mr. Waltz, I apologize. You had stepped back in the room, and you are now recognized.
Thank you, Chairman. I appreciate it. Thank you all for being here. And I know that getting away, it is important to not get into the specifics, although many times that's what we want to ask, to get away from the sweeping generalizations, but maybe because you're experts in this, and especially labor law, to help us in what we're getting up against and what we hear, and you're hearing it in some of the questions is, maybe go to you, Ms. Bradley, first, and then maybe Mr. Bachman help me with this. When I hear this from constituents, when they hear some of these stories, and whether they're egregious or they're the norm, that's our job to figure out. But when they say, you know, if this kind of stuff happened in the private sector, they'd be gone tomorrow. There wouldn't be anything be gone tomorrow. Is that a true statement? Are you at a different standard? Is there differences there? And again, I understand striking that balance between doing the right thing, having managerial authority, and due process. How would you respond to that when someone walks up to one of us and says that?
I think it's a fair statement that there is less regulation in the private sector surrounding personnel disputes or employment disputes. I think they are regularly settled. I know from my law firm days in seeing them that they were regularly settled. So I think that there's a perception that there's less regulation, that there is less chance of litigation. There are more rights for public or federal employees, I suspect, I don't think anybody would disagree with that, than in the private sector. But I think we have made some good strides in trying to move more expeditiously in our accountability actions, and I think that the American people deserve that.
And so we should also take, and I don't have the data on this, to know of protections on wrongful terminations or some of the things we're talking about on whistleblowers that you might not get in that. So with the ability to sweepingly move someone, you can sweep up people who were doing the right thing, and so it's striking that balance. And so your contention is, Ms. Bradley, that we're moving in that direction to strike the proper balance between a worker's rights, due process, but also, if you will, a veteran's due process to make sure that a bad employee's gone.
We have to do that. We aren't in the business at VA of litigating and dealing with employment disputes all day. We're in the business of providing the best health care possible for our nation's veterans, for adjudicating claims quickly, for burying our heroes appropriately. So it's striking a balance and running the business, managing the business. We may be in the public sector, but we are running businesses. And so, yes, that's something that's hard for leaders to do, but we have to do it.
Yeah, we need to work that part out, because I do think then there's that belief that, well, you're just, again, it's been mentioned, and again, if it's anecdotal or not, but the public certainly hears this a lot, well, it's just easier for us just to pay this and move on. That's not really the answer the public wants from a taxpayer perspective, or I think from doing it right. So I guess we're trying to strike that balance of giving you the right tools to do it while protecting them. But it's your contention, as you're saying, and we'll hear some of the data, that cultural shift is moving in the right direction. Because I could agree with you on this, and I keep coming back to this. I've heard Dr. Shulkin say it. I've heard the Secretary say it. Many of these things start with leadership, and starts with the leadership culture, the leadership incentive, that if it starts there, many of the things we're talking about never get to that point. Would you agree that that's...
Completely.
And you feel it's moving in that direction?
I do.
All right. What's the role of OSC in all of this, then, in terms of changing culture, following up, making sure that, I mean, I think most of us here agree, the best thing we would want is to be able to keep good employees, give people due process, and be able to move folks on who should be moved on.
Now, our central role is to help whistleblowers and protect whistleblowers when they come forward. So if a VA whistleblower comes to us and we have reason to believe they've been retaliated against, we want to help them. We want to help them get back on their feet and back on their job as quickly as possible. And I think it sends a message, whether it's through settlement or some other mechanism, when that employee who blew the whistle, who shined a light on an important issue, who had been fired, when they're brought back into that facility through settlement or some other mechanism, it sends a message. It sends a message that the employee will be protected, that things are changing. And as we have said in other testimony on other occasions, we do believe the VA has made positive steps in terms of tone at the top and the importance and value of whistleblowers at the VA.
No, I would agree with you, but I think it's a valid point that members here have made, that I agree with you on that. But if they go back into that institution and the very people who were there are still there, I think all of us know just by human nature that's a very challenging one. So we look forward to working with you on this and appreciate you being up here today. I yield back, Chairman.
Thank you very much. Mr. Costello, you're recognized.
Thank you, Mr. Chairman. As I understand it from reading the materials as well as listening to the questions, there's really two perspectives of concern, or at least two perspectives of concern, and they're not mutually exclusive. First, I don't think that anyone wants to see a frivolous filing of a claim result in a settlement. Now, I understand, I think somewhere in the materials, the nuisance value of these suits is at least $35,000, maybe more it costs you to defend a claim, and it probably is a little bit more of that. It would be helpful to know or cite two examples to address that concern where you have successfully defended to the bitter end a frivolous claim just because you do not want to develop a reputation for, they filed a suit, let's just settle it. I can tell you as a formerly practicing attorney and someone who served in local and county office, when Insurance Defense Counsel would come to us and say, such and such filed a claim, we think it's frivolous, we think it's hogwash, we think you should defend it because you do not want to be in a situation where you develop a reputation where you just settle everything, because that invites more claims. So information related to where you have not been willing to settle on that basis and candidly spent more money defending it than you would have spent had you just settled it. I think that we want to see that because I think that that's what you want plaintiffs' counsel who bring these cases to know. The inverse of that is the situation where a claim has been filed, and I think we can all concede that sometimes these cases, I mean, there's a little bit of unclean hands all around, but where a claim is filed, it paints some supervisor or someone in the VA in a very unflattering position, and there is at least some merit to the factual basis underlying the claim. I think that there is a rightful concern if that is passively settled in order to basically protect that supervisor. We don't want to see that happening either. That invites the question, in my mind, out of the 200 so cases that I think that we're using sort of as a data pool here, how many times has that claim been defended to the end, there been a finding of guilt, and that supervisor or employee who was the aggressor to the claimant been fired? Because there is, I think, a frustration that there's wrongdoing and people get reassigned, or this sort of gets buried in paperwork, and there's actually, to the accountability question you had mentioned, there's a duty of accountability that extends beyond the life cycle of the claim. Can you provide some instances where that accountability has resulted in people no longer being employed by the VA? The final point, if you could provide me some clarity on, is, and that would relate to whistleblower claims as well. The final question, and then I'll just leave it open, is this clean record settlement. All right, I don't think anyone wants to see clean record settlements where people have done really egregiously things wrong, or even things that they shouldn't have done. But you mentioned the neutral reference. Can you at least expound a little bit further on what that means? Because if the only people that get neutral references are people that did something wrong, that's fine. I think we want to make sure that there is at least some distinction between a neutral reference. I could have somebody work for me in the past that, they didn't do anything wrong, but I'm not so sure I felt that they'd be good for an organization, where I may say, I'm not going to say anything. That's actually different than someone who has done something wrong, but rather than disclose it, you provide a neutral reference. Do you understand that distinction? So those would be the three sort of areas that I'd be looking for your feedback. Thank you.
So let me take the neutral reference first. I had to do some digging on this myself. And so generally what it means is that the agency, when asked, will simply state the dates of employment, the performance rating of record at the time of departure, and the highest grade and title held. And so generally when somebody from the other agency, pick an agency, gets that information, red flags go up, because it's a very consolidated set of facts. And with respect to, would we give a neutral reference for somebody who hadn't really engaged in any wrongdoing, that would be a different conversation. This is more formulaic, I guess is what I'm trying to say. It's formulaic. It would sound wooden, and there would be red flags that would go up. With respect to the examples that you've asked for, I'd be happy to provide them to you. I can't provide them to you just off the cuff, but not only would I be happy to provide them to you, it might be good for us to use in our training, now that you mentioned it, because I want everyone in the department to understand that we're willing to go all the way when we need to.
And I can certainly speak anecdotally from my personal experiences of taking a case all the way to litigation because I believed absolutely that we did not do anything wrong with that employee, and we won. And so it does indeed happen, at least from one person's personal experience.
I see my time is up. The part that you didn't get to was the sort of passive settlement where we don't get to the accountability, and I can just say from a culture perspective, I don't think I'm the only one that feels this. It's nice to see, that's a weird way of putting it, it would be helpful to see the examples where someone has filed a claim, a supervisor has done wrong, and that supervisor has been held accountable by them being fired, because there's still a feeling that we don't ever get to that last part. There's reassignment, there's some sort of paperwork shuffle where they're in a different title or a different part of the country, and it's just sort of swept under the rug. Thank you for allowing me to go over my time, Mr. Chairman.
Very good. Before I recognize Ms. Rice, can I ask one question, Ms. Bradley? Can you, if you have two equal candidates, and one of them has a neutral recommendation, can you not hire that person based on that neutral recommendation?
Do you mean may the agency choose not to hire the person based on the neutral recommendation? Of course, absolutely.
Okay. Ms. Rice, you're recognized.
Thank you, Mr. Chairman. I just want to continue on what Congressman Costello was talking about, but I don't know if this is information that the chairman and his staff have, but I'm curious as to what the total amount of settlement amount was for 2015, if you have those numbers.
That was not in the request to us for the hearing, but we could certainly pull that together,
I'm
I
just
think.
curious, because
and
it seems
provide
to me that, and this is a question for you, Ms. Bradley.
If the gentlelady will yield, it's $5 million
For 2015,
since July 2014.
since July 2014. Okay. Thank you, Mr. Chairman. So my question is, we're talking about all of these financial settlements. Are there other outcomes? And can you talk about them?
Yeah, thank you so much. Actually, I said it briefly in my opening statement, but I don't know what the exact percentage is, but oftentimes we are able to resolve employment disputes with no monetary payout. Sometimes it could be something as simple as, would you move me from the person I don't like working next to? Could you move me to a different location in the facility? Or, I didn't compete effectively for a promotion. Could you promise to put me in for this certain kind of training this year so I'll be more competitive? There are so many things we can do to resolve employment disputes short of paying money, and we do it all the time. I think in the EEO context, we might be able to give you more graphically in the informal resolution stage what the kind of percentages of non-monetary payouts versus monetary payouts. But it is significant, the numbers of complaints that we can resolve with no money.
And so if you can just take us through this process. If someone, they either come directly to you or a complaint is fed up to you, comes up to you through a chain, and you then begin to address the mediation or you working out the issues. If you, during an interview with an aggrieved employee, learn that they are, in fact, a whistleblower who's being retaliated against, what is your responsibility vis-a-vis that information that you get? And we've talked a lot about the outcomes with whistleblowers, but what is the process for the wrongdoers? And can you give examples of them being held responsible? And how does that work?
Well, you've talked about really 3 or 4 different kinds of employment disputes that have different kinds of processes and procedures associated with them. So could we take EEO as the first bucket of employment disputes? The reason I pick EEO first is because that is the majority of our employment disputes. And those are handled in a very regular course of business through an office called the Office of Resolution Management. Again, I think that I mentioned before that the Deputy Assistant Secretary who leads that office, Harvey Johnson, is here today with me. So there are processes and procedures that require informal discussions of settling the matter. When I say settle, I don't mean like payouts. I mean like, let's talk. Let's get the aggrieved party, let's get the manager in a room, let's have a neutral in that room with those 2 parties. Let's see if we can work this out informally without having to have a formal investigation. If that process breaks down, then you move to the next level in the EEO process, which is a formal investigation. So you're gonna have witness statements, you're gonna have transcripts, you're gonna have court reporters and things like that. And then if it has to go beyond the formal stage in the Department of Veterans Affairs, it can either go to the EEOC, the Equal Employment Opportunity Commission, or it can go to an arm of VA called OEDCA that will make final decisions. But there, if we go all the way to those 2 entities, then there's going to be some finding of wrongdoing, some finding of fault. I don't think I'm answering.
Are you responsible for imposing a punishment or
No, I really have nothing to do with any of this process. I'm the chief legal officer for the department, so I might be responsible for helping train or to explain the laws. But no, those processes are carried out at the local level through, take it away, Mr.
So
Young.
an OETCA decision would come back to the medical center director describing the improper actions that a supervisor would have had in the medical center and the proposed actions that should be taken on that. And then we take those actions and then need to report that back up to OETCA.
Mr. Brockman, any deficiencies you see in terms of the treatment of whistleblowers versus that of those who retaliate against them, in your opinion? And what, if any, recommendations would you make?
Well, if I can just add on a little bit to the process, and you were talking about accountability. When a whistleblower comes to us from any agency, but let's say the VA, files a complaint of whistleblower retaliation, we need to investigate that. At the same time, though, if the whistleblower and the agency wish to engage in settlement negotiations, we're going to encourage that because that's going to help the whistleblower get back on their job and back on their feet more quickly. But I want to be clear on this. Just because the whistleblower and the VA settle their claims does not mean that OSC's role in the case has to end. In fact, we have a number of ongoing disciplinary action cases in facilities around the country where the whistleblower and the VA have settled and OSC is continuing its disciplinary action investigation of subject officials. So I just wanted to be clear on that point. In terms of where the VA has come upon in terms of how they're treating whistleblowers, we have seen substantial improvement, but as I've said to Ms. Bradley herself and to others, there's still a significant room for improvement on that front.
No question about that. Thank you very much. I yield back, Mr. Chairman.
Thank you. Ms. Ryder-Wagon, you're recognized.
Thank you, Mr. Chairman. I welcome the panel. Thank you for your appearance today. Ms. Bradley, before VA compiled the documents to satisfy this committee's request, have you or anyone else at VA ever compiled all of these settlement agreements into one place for a nationwide review so you could see the overall cost to the taxpayers?
I have not.
Mr. Bachman, what level of transparency do you have into whether employees who retaliate against whistleblowers are properly disciplined?
As I said, our first mission, our primary responsibility at OSC is to make sure we're helping to protect whistleblowers. And through that, we have been using settlement agreements with the VA to make sure that they're able to get back on their job, continue serving veterans. And that's really needed to be our primary responsibility. At the same time, however, we have really been working to improve actions on the disciplinary front to help the VA improve accountability there. And to that end, we've got these several ongoing disciplinary action investigations I've mentioned. But I think an important one to point out is that over the last few years, the VA has disciplined over 40 VA employees who were implicated in wrongdoing that was brought to light by VA whistleblowers who would come to OSC to make their whistleblower disclosure there. And I think that's an important point because it shows the role that whistleblowers as well as OSC can take in helping the VA to improve their accountability. 2 of those 40 folks that the VA has disciplined, those involved removals of high-level officials at the Fort Collins, Colorado facility, which was struggling with the wait time manipulation problem there. So I think there has been an ability to take some accountability, not always through the strict litigation sense, but through other coordination between OSC and VA.
Thank you. And Ms. Bradley, has any thought been given to doing what it is I asked about? In other words, you say nothing's been compiled, but has any thought been given to such a possibility?
Well, I don't want the committee to believe that nothing's been compiled. You asked me if my office, I'm in the Office of General Counsel, we didn't compile that data. We don't track the total number of payouts. I think that it's fair to say that the administration's are very attentive and track that information as they should, because again, these are business decisions and the money comes out of their operating budget. I would say what I track as the general counsel is, can we show our veterans, can we show the American people, can we show this committee that when we uncover wrongdoing, whether it's racial discrimination or whether it's whistleblower retaliation or something along those lines, can we show the American people that we will hold those wrongdoers accountable? That is what I've been really focused on doing in my office, focused on doing it in our training, focused on doing it with respect to the stand-up of the office in my shop called the Office of Accountability Review, ensuring that we have put really top-notch investigators on the Office of Accountability Review so they can provide to us competent investigations with sound evidence so that when we take these actions, we won't have them overturned. Those are some of the things that my office and that I personally have been focused on.
And speaking as my previous job as a medical center director, that was a fundamental piece of what I looked at regularly with the rest of the leadership team was, for example, the number of EEO complaints that we have, the number of labor grievances, those sort of human resource indicators that would give us a sense of the health of the organization.
And from a VBA perspective, we do the same thing at the district. Obviously, we're probably a fraction of the size of VHA, so we can look even closer at those agreements from a enterprise level. So at each of our districts, as well as in our Office of Resolution Management within VBA, we do that same thing.
Thank you, Mr. Chairman. I yield back.
Thank you very much, Ms. Radewagen. Ms. Bradley, Dr. Benishak.
Well, thank you, Mr. Chairman. I'm going to touch on something a little bit different than I think the whole gist of the meeting here this morning is, and that is my concern is that the average employee is not getting evaluated in the process of making sure that infractions are not documented, so that we have to use this special agreement thing because you don't have the documentation in the record to justify the disciplinary action stuff. And, you know, a couple of years ago, Gina Farisi, the Assistant Secretary of Human Resources and Administration at the VA, told me and this committee that she was writing her own evaluation, and that it was common practice for employees to write their own evaluations and have them simply be signed off by their supervisor. And, you know, in my opinion, that's a way for make it easier for the supervisor, but it doesn't really document any problems that might be there with the employee. And then later on, when, you know, the problem is worse and worse, there's no documentation in the employee record that there was a problem that was attempted to be corrected. Is that still going on in the VA? This was 2 years ago, she told me that.
I think that it is an issue, and it's so much of an issue from my perspective that I've had several meetings with my top lawyers, so that would be our district chief counsels and the deputy district chief counsels.
So it's still going on then?
I don't want to say it's still going on. I would say it's still a concern for me. So what I've said to my attorneys is for each and every case, when your clients come to you and they start to talk about how they might want to settle a case, I expect you to be proactive and talk about why it is that maybe the record looks a little, let's just say it's not as strong as it could be. And the reason that the record might not be as strong as it should be is because there wasn't proper documentation.
Well, that's my whole point here. Maybe,
Yes,
you know, if
it's
the
a
managers
risk.
have a better control over the nuts and bolts, the blocking and tackling of doing their managerial jobs, then we wouldn't be resorting to these special things so often, okay? Mr. Young, you mentioned that you're a former medical center director. So are you having any familiarity with this problem of people writing their own evaluations?
I think
Have you ever written your own evaluation?
I do a self-assessment, an honest self-assessment where I look in the mirror and I look
That's not signed by your VISN director as your evaluation for the year.
I write my self-assessment and I provide it to the network director, and he then evaluates me and writes what he thinks about me and then rates me. And then it goes before a panel within
So you're not familiar with this process of people writing their own evaluations?
writing a self-assessment, yes.
I'm not aware of that problem either.
Well,
I am aware that we
I had
have
an
had cases.
assistant secretary for human resources tell me she was writing her own evaluation and that it was common practice. And I just don't want to see that continue to be a common practice because, as I mentioned, the reason I'm asking these questions is it doesn't allow for documentation of bad behavior and corrective action efforts and all that.
So if I could address that, from a VBA perspective, the executive as well as our employees, as part of the performance review and performance rating process, they are asked to say, from your perspective, how do you view what you've done this year? That is input to the rating that I do on the individual, but it's not the final say. The senior leader or the rater is the final say on the assessment of that individual employee. So Ms. Pharisee may have indeed said that she wrote her own, but she could have been speaking about a very specific part of your performance appraisal, which is your self-assessment, which becomes a part of the record.
So how many times have you written these yearly? Everyone underneath you, do they get a yearly assessment?
So I will speak to my old job, because I've been in this one for about 2 months. So as the chief
Yes
financial
or
officer,
no? Have you written these assessments for other people?
so my
Do they-
deputy has written assessments on my employees that worked for me, and then I wrote the assessment of my deputy. On every of the employees that worked directly for my deputy, I was the senior reviewing official. So let's say that.
How often do these assessments have a corrective action plan or some sort of a recommendation for improvement?
So I can't speak to that because
So you've never done that?
I've not had the reason to do that.
I can, from my experience, I would always ask my employees to provide a self-assessment, but then I would also write an assessment of them, and in that assessment, the last paragraph would very typically be, these are my expectations for them for the coming year and the areas that I believe that they have opportunities to improve.
And then, is that ever checked again?
Absolutely, and then in the, always do a mid-year review, and just good management is having regular conversations with your direct reports about the progress that they're making in their work lives.
All right, I'm out of time. Thank you, Mr. Chairman.
Thank you, Doctor. Ms. Bradley, if settlement agreements are tracked and handled locally, and you don't track them, or it doesn't appear anybody at the central office tracks them, how can this committee be sure that we've received all of the settlement agreements that we asked for?
Well, again, I didn't say we don't track any of them. For those that are in the realm of EEO, those are tracked.
I asked, and I guarantee you know what I asked the secretary for.
Well, I know what your request letter said, yes, absolutely.
Yes, and how can I be sure that I got all of those?
Because we requested those from the various entities that keep the settlement agreements.
And how can you be sure that they gave you every one of them?
I suppose I can't be absolutely sure that
Okay,
they
very
gave
good.
me
Next
every one of
question.
them.
You cannot tell us about accountability actions in those 208? Nobody knows about any type of accountability action?
Of course we know about accountability actions. What I said was I couldn't discuss individual accountability actions.
So could you tell us about, though, just in a, let me see how to put it, in a broad way?
Yes.
Can you, well, I was trying to think of something else, but I couldn't pull it up. Have you done an analysis of the 208 cases that are out there on what accountability was taken?
I have looked at some of them,
Okay,
yes.
the answer is no.
I didn't say no. I
well-
said I have done some, and especially those that
Have
have
you done on
gotten to
all
the secretary or the
208?
deputy
Ms.
secretary.
Bradley, my question was, have you done an analysis on the disciplinary action on all 208? Your answer is you've
Is
done
some.
some. On
Is some.
So The answer is no, you haven't done on all.
My answer is that I've done it on some.
My
is my
question
answer.
is, have you done it on all of
I
them?
understand. That's where I
Okay?
am. I've done it on
And the answer is
some.
no. Thank you very much. Also, members, just for your personal information, we did an analysis. 72% of the 208, there was a monetary payout. You were talking about many not, but many is not 72%. That was either people received money or their attorneys received money. That's an analysis that we got of the 208. And let me also, for the record, and I'm going to be very cautious because even though I could, through speech and debate, talk about a particular settlement agreement, but I want to let you know about one in particular, that there was a Inspector General report, there was a AIB that was done. Both of them said this person should be terminated and removed, and this is what the settlement agreement ended up being. And this is why, even though you talk about not being monetary payouts, this person's still employed at VA. They were agreed to give a 2015 performance rating of fully successful with no negative narrative regarding the issues that were addressed in the proposed removal. They had 137 hours of annual leave restored into their annual leave account. They agreed, they being the department, that there would be no disciplinary action taken against this individual for any matters or acts known or that should have been known to VA before the effective date, which means what they didn't know, they can't go back at this point and discipline this individual. The VA agreed to give this person a letter of reference and also pay their attorney's fees. This is for a person that was recommended for removal. I just don't understand how it could go from removal to all of this. And so this person still is employed at the department, and they were charged with retaliating against whistleblowers. It just doesn't make sense that something like that would be allowed to take place. Mr. Takano.
Oh, well, Mr. Chairman, I mean, certainly the minority does not agree with any practices of the VA which would encourage the retention of bad employees. And certainly we want to see accountability occur at the VA. But I just want to ask Ms. Bradley, is the VA are you able to talk about and respond to the chairman's particular case, even if he were to tell you who this person was? You could talk to him, and go ahead.
I would very much like to. I can't do it in a public hearing, and we've got to do it with context. So I have to know exactly which case he's talking about. I have to make sure that I have all of the facts. But yes, we've offered that. In fact, I think we've done that on a number of occasions. We've brought over the relevant experts to talk with the committee. We want to be completely transparent. And I don't know when this case took place. I can tell you that is antithetical to the leadership of Bob McDonald and Sloan Gibson in the area of accountability. It's antithetical to my leadership. So I would very much like the opportunity to do that in a closed session.
Will the gentleman yield?
I yield for
very quickly.
comment, yes.
We did get a briefing on this particular issue, and the answer was the department had to make a judgment call. That was the answer.
Okay, Mr. Chairman, I hope that you might meet with counsel and see if Ms. Bradley can explain any further. You have. It's not been satisfactory. All right. Well, I would like to go to, I don't have any more questions on my side. Can we go to closing?
Yeah,
statements?
you're recognized close.
Okay, great, thank you. Well, I don't want to thank you for the hearing, Mr. Chairman. I mean, I thought Mr. Costello's questions were very good. I thought we had good questions on all sides. And I feel we've done a good job of beginning what I hope will be an ongoing involvement in these matters with VA as the agency works to reform its culture, because I agree with Ms. Brownlee and Ms. Bradley That is the key element in that effort, is changing the culture. I want to let Mr. Berlarakis know that I want to work with him on a way to get a better concrete handle on the numbers of agreements, their terms, and the cost to VA down the medical center. And it would be helpful, Ms. Bradley, if we could be absolutely sure that all those agreements are back. I mean, I don't want any feeling that there are agreements that your administrators out there could keep from the attention of the Secretary or your office. So we need to have a way to make that absolutely certain in law and in policy. And I would join the majority in such an effort to make sure that that happened. Finally, I look forward to that detailed briefing on the new data analytics program briefing that Ms. Bradley has offered us as a follow-up to this hearing. And I am myself, that wasn't quite the last point, I was quite interested in the kind of training that has occurred. This has been a theme, I think, raised by also the Commission on Care co-chairs in their testimony before us, their amazement at the relative de-emphasis or the undervalue of the personnel department. And I think that connects to much of the legal liability that you have to defend against when our managers and supervisors are not adequately trained. And if they're not adequately trained on what retaliation is or what it means to have whistleblowers, so retaliation is a serious problem, not in the VA context as a workplace, but workplaces across this country, public and private. And but I think we also need to examine how we can empower our managers and supervisors and executives to hold employees more accountable through progressive discipline, that they're thoroughly trained on how to issue progressive discipline, and also to document employees properly. I mean, your office cannot pursue cases of dismissal when the managers are not doing all the things they need to be doing. And there is, I think, admittedly, an onus, but not an insurmountable onus, and a reasonable onus. But that's all the more reason why we need better trained personnel. I'm curious to know whether we are doing enough, and we've heard two private sector leaders of healthcare organizations, healthcare providers, who both raise this question. And I would love to engage with the majority more on this topic. And I welcome us examining the streamlining of an overly burdensome due process. But I don't think we should focus on due process alone. We should also be focusing on are there missing pieces for our managers, both in terms of retaliation, whistleblower protection, but also progressive discipline, which is, I think, the key. And that done effectively, that is a powerful tool for changing the culture of an organization. So that's my final comment.
Thank you very much, Mr. Bradley. Mr. Bachman, thank you both for being here. Ms. Bradley, you always do a very good job as the lead attorney for the Department of Veterans Affairs, which means it's very difficult sometimes for us to get the answers that we're looking for, but I understand who you work for. To both of your colleagues that have joined you, thank you for your service to the department. We will continue focusing on this particular issue. I would ask that all members would have 5 legislative days with which to revise and extend their remarks and add extraneous material. Without objection, so ordered. This hearing is adjourned.